Good day, everyone. Today we'll explore an important topic in the law on contracts, voidable contracts, under Articles 1390 to 1402 of the Civil Code. By the end of this discussion, you'll know 1. What voidable contracts are, 2. When they can be annulled, 3. How they can be ratified, and 4. The effects of annulment. Let's begin. Article 1390. The following contracts are voidable or annullable, even though there may have been no damage to the contracting parties. 1. Those where one of the parties is incapable of giving consent to a contract. 2. Those where the consent is vitiated by mistake, violence, intimidation, undue influence, or fraud. These contracts are binding unless they are annulled by a proper action in court. They are susceptible to ratification. Meaning of voidable contracts. Voidable or annullable contracts are those which possess all the essential requisites of a valid contract, but one of the parties is incapable of giving consent, or consent is vitiated by mistake, violence, intimidation, undue influence, or fraud. Binding force of voidable contracts. They are valid and binding between the parties, unless annulled by a proper action in court by the injured party. Once ratified, they become absolutely valid and can no longer be annulled. See comments under Articles 1327, 1328, 1330. Note that the existence of economic damage is not essential for their annulment, as in the case of rescissible contracts. The contract is void, not merely voidable, if it is a contract of marriage. Kinds of voidable contracts. A contract otherwise legal in object and operation is voidable because of a defect caused by either 1. Legal incapacity to give consent, where one of the parties is incapable of giving consent to the contract, or 2. Violation of consent, where the vitiation is done by mistake, violence, intimidation, undue influence, or fraud. Meaning of annulment. Annulment is a remedy provided by law, for reason of public interest, for the declaration of the inefficacy of a contract based on a defect or vice in the consent of one of the contracting parties in order to restore them to their original position in which they were before the contract was executed. Period for filing action for annulment. The 4-year period for bringing an action for annulment of a voidable contract is reckoned. 1. In cases of intimidation, violence, or undue influence, from the time the intimidation, etc., ceases. Before that time, the consent is still being vitiated, and therefore, the victim cannot be expected to bring an action in court. 2. In case of mistake or fraud, from the time it is discovered. This must be so, because before the time of discovery, the innocent party is unaware of the reason which renders the contract voidable. Article 1393, and cannot also be expected to bring an action in court. Furthermore, the guilty party should not be rewarded for successfully hiding the mistake or fraud. 3. In the case of contracts entered into by minors or incapacitated persons, from the time the guardianship ceases. An incapacitated person has no capacity to sue. Article 1392. Ratification extinguishes the action to annul a voidable contract. Ratification means that one voluntarily adopts or approves some defective or unauthorized act or contract, which, without his subsequent approval or consent, would not be binding on him. It indicates an intention on the part of the ratifier to be bound to the provisions of the contract. Article 1393. Ratification may be effected expressly or tacitly. It is understood that there is a tacit ratification if, with knowledge of the reason which renders the contract voidable, and such reason having ceased, the person who has a right to invoke it should execute an act which necessarily implies an intention to waive his right. Kinds of ratification. They are 1. Express, or in writing, or when the ratification is manifested in words. 2. Implied or tacit. It may take diverse forms, such as by silence or acquiescence, by acts showing adoption or approval of the contract, or by acceptance and retention of benefits flowing therefrom. Requisites of ratification. 1. The requisites for implied ratification are the following. There must be knowledge of the reason which renders the contract voidable. Such reason must have ceased, and the injured party must have executed an act which necessarily implies an intention to waive his right. Examples: a minor, S, sold his land to B. After reaching majority, instead of repudiating the sale, S used the proceeds and even collected the balance, showing tacit ratification. Later, S tried to annul the sale, claiming threat and intimidation, but since he deposited and withdrew the purchase money, the contract was deemed ratified. Express and implied ratification require the same requisites, with the former done explicitly. Article 1394. Ratification may be effected by the guardian of the incapacitated person, who may ratify. A contract entered into by an incapacitated person may be ratified by the guardian, or the injured party himself, provided he is already capacitated. As legal representative of their wards, guardians have the power to contract on their behalf. Hence, they may also ratify contracts entered into by their wards, in case the contract is voidable on the ground of mistake, etc. Ratification can be made by the party whose consent is vitiated. Article 1395. Ratification does not require the conformity of the contracting party, who has no right to bring the action for annulment. Conformity of guilty party to ratification not required. Ratification is unilateral act by which a party waives the defect in his consent. The consent of the guilty party is not required. Otherwise, he can conveniently disregard his contract by the simple expedient of refusing to give his conformity. Article 1396. Ratification cleanses the contract 1519 from all its defects from the moment it was constituted. Effect of ratification, retroactive. Ratification cleanses the contract of all its defects from the moment it was executed. It extinguishes the right of action to annul. In other words, the effect of ratification is to make the contract valid from its inception, subject to the prior rights of third persons. Example: B forced S to sell the latter's horse. Later, the horse gave birth to a colt. If S should ratify the contract after the birth of the colt, who is entitled to the colt? S, because ratification has a retroactive effect. It validates the contract from the date of its execution. If the horse had been sold by B to C, who acted in good faith, the subsequent ratification by S of the sale to B cannot prejudice C. The sale to B is valid until annulled by a proper action in court. Article 1397. The action for the annulment of contracts may be instituted by all who are thereby obliged principally or subsidiarily. However, persons who are capable cannot allege the incapacity of those with whom they contracted, nor can those who exerted intimidation, violence, or undue influence, or employed fraud, or caused mistake base their action upon these flaws of the contract. Right of strangers to bring action. One who is not a party to the contract or an assignee thereunder, or does not represent those who took part therein, has, under Article 1397 and Article 1311, no legal capacity to challenge the validity of such contract. Strangers, therefore, are without right or personality to bring the action, for they are not obliged by the contract, principally or subsidiarily, unless they can show detriment which would positively result to them from the contract in which they had no intervention or participation. Examples: 1. S sold a parcel of land to B. The consent of S was vitiated by fraud. Subsequently, S sold the same lot to C. In this case, C can bring an action to annul the sale. 2. S sold a piece of urban land to B. On grounds provided not by law, S or B can bring an action to annul the contract. But C, an adjoining owner of S, cannot ask for the annulment of the sale, as C is not obliged principally nor subsidiarily under the contract. However, C may question the sale if under the law, Article 1622.3, he has a right of redemption, i.e., the right to repurchase the property from B. In this case, C would be prejudiced if the sale is not set aside. Note: the exercise of the right of redemption by C will in effect annul the contract of sale between S and B, guilty party without right to bring action. The guilty party, including his successor in interest, cannot ask for annulment. This rule is sustained by the principle that he who comes to court must come with clean hands. Article 1398. An obligation having been annulled, the contracting parties shall restore to each other the things which have been the subject matter of the contract, with their fruits, and the price with its interest, except in cases provided by law. In obligations to render service, the value thereof shall be the basis for damages. Duty of mutual restitution upon annulment. 1. If the contract is annulled, the parties, as a general rule, must restore to each other the subject matter of the contract with its fruits. The fruits must be returned because the party who received them had no right to enjoy the same. The interest must be paid because the party who received the money had no right to use it. 2. In personal obligations where the service had already been rendered, the value thereof with the corresponding interest is the basis for damages recoverable from the party benefited by the service. Article 1399. When the defect of the contract consists in the incapacity of one of the parties, the incapacitated person is not obliged to make any restitution except insofar as he has been benefited by the thing or price received by him. Restitution by an incapacitated person. This provision is an exception to the general rule of mutual restitution under the preceding article. The incapacitated person is obliged to make restitution only to the extent that he was benefited by the thing or price received by him. It results, therefore, that if he was not benefited, he is not obliged to restore what he had received, but the other contracting party is still bound to return what he had received, whether he was benefited or not. An exception to the rule of mutual restitution is also provided in Article 1, 4, 2, 7. Article 1400. Whenever the person obliged by the decree of annulment to return the thing cannot do so because it has been lost through his fault, he shall return the fruits received and the value of the thing at the time of the loss, with interest from the same date. Effect of loss of thing to be returned. 1. If the thing to be returned is lost without the fault of the person obliged to make restitution, defendant, there is no more obligation to return such thing. But in such a case, the other cannot be compelled to restore what in virtue of the decree of annulment he is bound to return. Article 1402. If it is lost through his fault, his obligation is not extinguished, but is converted into an indemnity for damages consisting of the value of the thing at the time of the loss, with interest from the same date and the fruits received from the time the thing was given to him to the time of its loss. Example: S sold his plow and carabao to B. On the petition of S, the contract was annulled by the court. But the carabao died in the possession of B through his fault. Under Article 1400, B must pay the value of the carabao at the time of its death, with interest from the same date. If the carabao had given birth, the young must also be delivered as the fruit of the said animal.
Art.1401. The action for annulment of due contracts shall be extinguished when the thing which is the object thereof is lost through the fraud or fault of the person who has a right to institute. If the right of action is based upon the incapacity of any one of the contracting parties, the loss of the thing shall not be an obstacle to the success of the action, unless said loss took place through the fraud or fault of the plaintiff. Art. 1402. As long as one of the contracting parties does not restore what in virtue of the decree of annulment, he is bound to return. The other cannot be compelled to comply with what is incumbent upon him. Example, if the horse died through the fault of B, Article 140 governs. If the horse died due to a fortuitous event, S can refuse to return the purchase price. With or without the fault of B, S, as injured party, has the right to demand the value of the horse with damages.
Enforceable contracts under Article 1403 of the Civil Code. By the end of this short session, you'll know what makes a contract unenforceable, the 3 types covered by the article, how the statute of frauds works, and the ways unenforceable contracts can become enforceable. First, definition. An unenforceable contract is one that is valid in form but cannot be enforced in court unless it is ratified. In short, the contract exists, but the courts will not enforce it yet because of a legal defect, until the defect is cured. Binding force, rescissible and voidable, valid and enforceable until rescinded, annulled. Unenforceable, valid but not enforceable in court unless ratified. Once ratified, becomes enforceable. Kinds of unenforceable contracts. Article 1403. 1. Unauthorized contracts. No authority acted beyond powers. 2. Contracts not complying with the statute of frauds must be in writing. 3. Contracts where both parties are incapacitated. 3 types. 1. Without authority. Contract entered in the name of another by a person with no authority legal representation, or who acted beyond powers. 2. Violation of statute of frauds must be in writing, signed by party charged, not to be performed within 1 year. Special promise to answer for debt default of another. Agreement in consideration of marriage, except mutual promise to marry. Sale of goods to P500 unless partly delivered, paid. Both parties incapacitated. When both lack capacity to consent. Unenforceable meaning of unauthorized contracts. Unauthorized contracts made in the name of another by someone without authority legal representation or acting beyond powers. Governed by Article 1317, contracts made in another's name. Principles of agency. Articles 1868, 1883, 1901. Article 1404, Statute of Frauds. The Statute of Frauds, first enacted in England in 1677, was designed to prevent false testimony and perjury in cases involving certain contracts. It made specified agreements unenforceable unless supported by a written memorandum signed by the liable party. Adopted in the Philippines with modifications, its purpose is to prevent fraud and honest mistakes by requiring certain contracts, Article 1403, to be in writing, ensuring reliable proof of the party's intent. The writing need not be formal. Even a slip of paper, note, or letter is sufficient as long as it clearly records the agreement. Application of the statute of frauds. Not applicable to actions other than for damages or specific performance, e.g., ejectment suits may prove oral sales. Applies only to completely executory contracts. No performance yet by both parties. Not to executed or partially performed contracts. Partial performance supplies evidence of intent and prevents unfairness. Not applicable if the contract is admitted, either expressly or by failure to specifically deny its existence. Covers only the agreements enumerated in the statute, e.g., easement of right-of-way not included. Not applicable when the writing does not reflect the true agreement of the parties, since it cannot be used to shield or perpetuate fraud. Contracts infringing the statute are not void, only unenforceable unless ratified. The defense may be waived, e.g., by failure to object to oral evidence. Defense is personal. Only parties to the contract may invoke it. Strangers cannot. Agreements within the scope of the statute of frauds. To be enforceable, a contract does not have to be in writing. In fact, most contracts made orally are legally enforceable. However, there are agreements which fall within the scope of the statute of frauds enumerated below, which are not legally enforceable in court, although valid, unless the same be in writing. In other words, if either party refused to comply with their agreement, the same could not be enforced. 1. Agreement not to be performed within 1 year from the making thereof. Example: on October 10, 2018, S entered into an oral contract with B for the construction of B's house to begin on October 20, 2019. The contract must be in writing to be enforceable. In order for this provision to be applicable, it must appear that the parties intended when they made the contract that it should not be performed within a year from the date the contract is entered into by the parties, and not from the date it is to be effective. A contract is within the statute if the time for the full performance of the contract exceeds a year, although the excess is ever so little, e.g., one day. 2. Promise to answer for the debt, default, or miscarriage of another. Example: Dow's C 50,000 with G as guarantor. Here, G has a special promise to answer for the debt of D in case D fails to pay the same. This promise is unenforceable unless it is in writing signed by G. Note that in a guarantee, the promise is merely subsidiary or collateral to the promise of another, the original or principal debtor. If the promise is an original or an independent one, that is, if the promiser, surety, becomes thereby primarily liable for the payment of the debt, the promise is not within the statute and may be proved by oral evidence. Thus, in the same example, if the promise of G is to pay C what D owes him, C, G's promise, even if verbally made, is enforceable as it is not a collateral promise to answer for the debt, default, or miscarriage of another. This type of agreement is a suretyship under which the surety binds himself directly and primarily responsible with the principal debtor on the original contract. 3. Agreement in consideration of marriage, other than mutual promise to marry. Agreements made because of marriage, e.g., M promises to build a house if W marries him, must be in writing to be enforceable. The rule applies even if the promise is made by a third person in favor of one of the spouses. A mutual promise to marry does not need to be in writing and may be proven by oral evidence in an action for damages. The statute does not cover the marriage itself, but related engagement contracts or property agreements made in consideration of marriage. Examples of agreements within this scope: marriage settlements, antenuptial contracts, fixed property relations before marriage. Donations propter nuptias, donations made before marriage in favor of one or both future spouses. 4. Agreement for sale of goods, etc. at price not less than 500. Examples: 1. S and B mutually promise to sell and buy a piano at a price of 12,000. This contract must be in writing to be enforceable against either party unless there is delivery or partial or full payment, in which case it is taken out of the operation of the statute of frauds, and the contract may be enforced even if it was made orally. If S denies a contract of sale of goods worth 500, but B claims the price is only 450, which is less than 500, oral evidence of the sale is admissible inasmuch as the true agreement claimed is not covered by the statute.
6. Agreement for the sale of real property or of an interest therein. Examples: 1. S orally sold his land or his right of usufruct in said land to B. The agreement is also unenforceable unless it has been partially executed. 2. S'agreed in a private document to sell his land to B. The document was given to B, who lost it. May B prove the agreement by oral evidence? Yes. Here, what is to be proved is not an oral, but a written contract of sale. It is necessary, however, that B first present proof that the written agreement really existed. 7. Representation as to the credit of a third person. Example: D is seeking a loan from C. T represents to C that D is solvent and has a good credit reputation. Relying upon this representation, C extends a loan to D, who actually is insolvent. The representation of T, which was made to induce the extension of credit to D, must be in writing to be enforceable. Here, there is no promise by T to answer for the debt of D. Note that there is no agreement involved. Article 1, 404 directly refers to Article 1, 317, which explains that a contract executed in another's name without proper authority is unenforceable. This means that the unauthorized contract lacks legal effect until the owner of the rights or property involved gives their consent or approval. Article 1, 405. Contracts infringing the statute of frauds, referred to in Number 2, Article 1, 403, are ratified by the failure to object to the presentation of oral evidence to prove the same, or by the acceptance of benefits under them. Modes of ratification under the statute. The ratification of contracts infringing the statute of frauds may be effected in two ways. 1. By failure to object to the presentation of oral evidence to prove the contract. The failure to so object amounts to a waiver and makes the contract as binding as if it has been reduced to writing. The requirement of a written form is for evidential purpose only. And 2. By acceptance of benefits under the contract. In this case, the contract is no longer executory, and, therefore, the statute does not apply. This rule is based upon the familiar principle that one who has enjoyed the benefits of a transaction should not be allowed to repudiate its burdens. Article 1406. When a contract is enforceable under the statute of frauds, and a public document is necessary for its registration in the Registry of Deeds, the parties may avail themselves of the right under Article 1357. Right of a party where contract is enforceable. A party to an oral sale of real property cannot compel the other to put the contract in a public document for purposes of registration because it is unenforceable, unless, of course, it has been ratified. The right of one party to have the other execute a public document is not available in a donation of realty when it is in a private instrument because the donation is void. Here, the seller and buyer again orally agreed to sell land for 1 million pesos. But in this case, no payment or delivery has been made yet. Since there is no performance, the contract falls under the statute of frauds. It is considered unenforceable, meaning the buyer cannot compel the seller to sign a public document. Third, void contract. For instance, a donor donates a parcel of land to a friend through a private document. Under the Civil Code, a donation of real property must be in a public instrument. Since this requirement was not followed, the donation is void for lack of form. Because of this, the donee cannot compel the donor to execute a public deed. Article 1407. In a contract where both parties are incapable of giving consent, express or implied ratification by the parent, or guardian as the case may be, one of the contracting parties shall give the contract the same effect as if only one of them were incapacitated. If ratification is made by the parents or guardians, as the case may be, of both contracting parties, the contract shall be validated from the inception.
Article 1408. Unenforceable contracts cannot be assailed by third persons. Right of third persons to assail an unenforceable contract. Strangers to a voidable contract cannot bring an action to annul the same. See Article 1397. Neither can they assail or question a contract because of its unenforceability. The benefit of the statute can only be claimed or waived by one who is a party or privy to the oral contract, not by a stranger. It is a personal defense. Examples. 1. S sells a parcel of land to B. The contract is oral. C binds himself in writing for the performance by B of his obligation to pay the purchase price. In an action by S to recover the purchase price, C cannot assail the contract between S and B for being unenforceable under the statute of frauds. C is a stranger to the contract. 2. Under a verbal contract, S sells a parcel of land to B. In an action for ejectment by B against C, the person in possession, the latter cannot set up the defense of the statute of frauds. 3. In the preceding example, suppose C maliciously induces S not to sell the land to B so that S sells the land to another. In an action by B against C for damages, see Article 1314. The latter cannot also invoke the statute of frauds. Thank you for listening. Hope you like it.